You have heard these words 1,000 times. In films, in television, in every police drama ever made, you have the right to remain silent. Anything you say can be used against you. They are probably the most famous words in the entire history of law. And yet almost no one knows where they actually came from. They were not written by ancient philosophers. They were not carved into some founding document centuries ago. They came from a single court case, in the 1960s, about a real and disturbing crime, and here is the part that makes the whole story so strange. The man whose name is now attached to your rights was not an innocent hero. He was guilty. His confession was almost certainly true. And still, the highest court in the country threw that confession out, and in doing so, changed the rights of every single person who would ever be arrested afterward. To understand why, you have to follow the case that forced a nation to answer one uncomfortable question: is a right you don't even know you have a right at all? It begins in Phoenix, Arizona, in the early 1960s, with a serious crime, the kidnapping and assault of a young woman. It was the kind of case that police were under real pressure to solve, and the kind of crime that makes it very hard to care about the rights of whoever did it. Following the evidence, police arrested a man named Ernesto Miranda. He was poor, poorly educated, and already known to the law. They brought him in, placed him in a small interrogation room, and questioned him. Picture that room for a moment: no windows, no clock, no one on his side. Just a man who barely understood the machinery he was caught in, and two detectives who understood it completely, asking their questions, hour after hour, until the walls themselves seemed to be waiting for an answer. And after a couple of hours alone with them, Miranda confessed. He signed a written statement describing the crime, a statement that, at the top, claimed his confession was made voluntarily and with full knowledge of his rights. On its face, it looked like an open and shut case. A dangerous crime, a suspect, and a signed confession in his own words. At trial, that confession was the centerpiece, and Miranda was convicted. As far as the state of Arizona was concerned, justice had been done. But there was a problem buried inside that interrogation room, a problem that would eventually unravel the entire conviction. Here is the problem. At no point, before or during that interrogation, was Ernesto Miranda ever told that he had the right to stay silent. He was never told that anything he said could be used to convict him. He was never told he could have a lawyer sitting beside him. Now, on paper, these protections already existed. The Constitution already contained a powerful shield against being forced to incriminate yourself, and a right to legal counsel. Those rights were, in theory, his all along. But theory was the whole problem. Because a right that exists only on paper, that a frightened and uneducated man alone in a room with detectives does not know he possesses, is not much of a shield at all. Miranda didn't stay silent because he had no idea that silence was an option the law allowed him. He didn't ask for a lawyer because no one told him he was entitled to one. And so his own lawyers built their appeal around a deceptively simple argument, that a confession pulled from a man who was never told his rights was not truly a free choice, and therefore should never have been allowed to convict him. And this is where a local crime in Phoenix became something far larger than one man. Because the question his case raised cut straight to the heart of what a right actually is. The government's position was, in a sense, reasonable. The protections existed, they were written down, they applied to everyone equally, and it was not the job of the police to give suspects a legal education. If people didn't know their rights, that was unfortunate, but the rights were still there. Miranda's side argued something deeper and more unsettling. They said that a right you have never heard of, that no one is required to tell you about at the exact moment it matters most, is a right that exists for the educated, the wealthy, and the guilty who happen to know the system, and effectively does not exist for everyone else. In an interrogation room, they argued, the power is wildly unequal. On one side, trained professionals who know every rule. On the other, often a scared and isolated individual who knows almost nothing. A right kept secret in that room isn't a protection. It's a trap. And so the case climbed, appeal by appeal, all the way to the highest court in the country. When it arrived at the Supreme Court, it became clear this was about far more than Ernesto Miranda. The court bundled his case with several others that raised the same core issue, and the justices understood exactly what was at stake: the balance of power between the police and the individual in that closed interrogation room. And the court was deeply, bitterly divided. On one side stood the justices who believed the Constitution's promise was hollow if ordinary people never learned it existed, that the only way to make the right real was to force the state to announce it, out loud, every single time. On the other side stood the justices who warned that this would tie the hands of the police, that guilty people would walk free on a technicality, that criminals would go unpunished because of a missed formality in a script. Both sides were describing a real cost. One was willing to risk letting some of the guilty escape in order to protect the innocent and the ignorant. The other was willing to accept that some people would never know their rights in order to keep confessions and convictions flowing. There was no option without a price. This is what makes the case so honest, and so hard. It was not a fight between good people and villains. It was a genuine collision between two things a fair society actually wants: catching the guilty, and protecting the powerless, with no way to have all of both. And the decision came down by the narrowest of margins, a single vote deciding the rights of a nation. The court ruled in Miranda's favor. His confession, very likely a true account of a real crime, was thrown out, because it had been obtained without ever telling him the rights he held. But the ruling did something much bigger than free one man from one conviction. It created a rule for the entire country. From that point on, before police could question someone in custody, they would have to clearly inform that person of their rights: the right to remain silent, the warning that their words could be used against them, and the right to a lawyer, provided for free if they could not afford one. Those words, the warning you have heard in 1,000 films, were, in effect, written into police procedure by this decision. The court's reasoning was that only a clear, spoken warning could level the impossible imbalance of the interrogation room and make the right against self-incrimination something more than ink on old paper. A right, the court decided, is not real until the person holding it knows it exists. And so a nation began reading suspects their rights, because of a guilty man from Phoenix. Now here is the twist that history almost seems to have written on purpose. Freeing Miranda's confession did not set Miranda free. The state of Arizona simply tried him again, this time without the thrown-out confession, relying on other evidence, and he was convicted a second time and sent to prison. The ruling protected a principle, it did not rescue the man. And his story ends with an irony so sharp it feels invented. Years later, after his release, Ernesto Miranda was killed in a bar fight. And when police arrested a suspect in his death, they did exactly what his own case had forced the entire country to do: they read that suspect the rights that now carried Miranda's name. The very warning born from his conviction was recited over the investigation into his murder. Think about the strangeness of that: the words that carry his name outlived him, and were spoken to protect the person accused of killing him. The man became a footnote in a story that everyone knows and almost no one can name. The words became immortal. So why does a single, narrowly decided case from the 1960s still shape every arrest today? Because it settled that uncomfortable question at the center of everything: a right that stays secret protects no one but the powerful. Those famous words are not there to help the guilty escape. They are there so that the frightened, the poor, and the uninformed walk into that interrogation room knowing the same thing the trained detective across the table already knows: that they do not have to speak, and that they are not alone. It is a small speech, a handful of sentences, and yet it quietly rebalances the most unequal conversation a person can ever be forced to have. That is why it survived, and why it is still spoken today, in the same rooms, for the same reason. It is one of the rare moments where the law drew its line not around the sympathetic victim, but around the guilty defendant, precisely because a protection that only shields the innocent and the well-informed was never really a protection at all. So let me leave you with the question the whole case turns on. If a right is never spoken aloud to the person who needs it most, does that right truly exist? Tell me in the comments. I read every single one.